Well, Public Protector Advocate Busisiwe Mkhwebane has applied for an urgent High Court application to halt the parliamentary impeachment proceedings against her. Mkhwebane wants the authorisation of the Section 194 committee to be declared unconstitutional and invalid. And she also seeks remedy on President Cyril Ramaphosa's intention to suspend her to be declared unconstitutional and invalid. Parliament says it will oppose Mkhwebane's urgent application after the DA lodged the complaint in 2020 following adverse legal findings against Mkhwebane. Now let's get the latest. We are now joined on the line by our reporter Bulelani Phillip. Bulelani, thank you so much for your time. Well, another court case, it seems. Talk to us about what this latest means.
Good afternoon to you and to the viewers. Basically, this is the latest court challenge by Busisiwe Mkhwebane, the public protector. You'll recall, if we take a step back, this motion has been raised by the DA in 2019, but because of the legal challenges, it has been delayed. And in February 2020, the DA actually resubmitted this motion, and it was approved by Parliament, which is the National Assembly. And at that time, they were saying that there are prima facie cases that need to be followed. Now, the question that came was that there were no rules at the time to be able to remove a head of a Chapter 9 institution. The National Assembly then resolved again that there needs to be a process that is legal, that needs to be followed in a removal of a public protector. The rules were created, and at the moment we are sitting with a public protector is challenging the very same rules that the National Assembly adopted. This case went to the Constitutional Court, where the public protector actually tried to halt the process of a removal. The Constitutional Court did decide that the inclusion of a former judge in the independent review panel, which composed of former Judge President was constitutional. However, the Constitutional Court directed that Parliament needs to be able to have the legal representation of the public protector when it comes to this matter. Those issues were concluded. 2 weeks ago, the President issued a notice to the public protector of his intention to suspend her. However, the public protector took issue with that, and she responded to say that I do not wish to comply with your directive or your proposal. And that proposal basically was saying is that I'm not going to be able to give you reason, and which is when she went to court, which is on Friday. In her court application, she's seeking 2 remedies. Part A is saying that the parliamentary process that has been initiated by the Section 194 committee must be halted. Part B speaks to the issue of the suspension by the President, to say that she also wants that process to be halted. Now, as we stand, Parliament is saying that it's going to be opposing all of those remedies that are being sought by the public protector. In fact, the Section 194 committee resolved last week that the process is going to continue. The timelines have been made clear to say that in the month of March and April, the public protector will be given all the evidence that is against her, which comprises all the complaints that were in the motion that was raised by the DA. Now, in the month of May, the public protector will be given a chance to respond to all of those allegations. In the month of June, the public protector will then be able to have her legal team over a period of 3 days to present her arguments and submit her evidence in terms of the allegations that have been leveled against her. The process will continue up until end of September. given that Parliament has given notice of continuing with the process, it means that there is no interdict that is preventing Parliament from proceeding with this in Section 194 inquiry. However, the High Court application that the Public Protector has made is scheduled to be heard on the 25th of this month or soon thereafter, which is according to the papers. So we still remain in the dark as to whether the court will rule in her favor or whether Parliament, as things stand, will continue with the process.
Bulelani, thank you so much for that comprehensive update. Now, let's get analysis. We are now joined by Advocate Paul Hoffman, Accountability Now Director. Advocate, thank you so much for your time. Advocate, if you've been listening to one of our reporters, Bulelani Phillip, just giving us basically just a timeline of where we are currently sitting. Is there a reason to believe that actually, even though we've got this development from Advocate Mkhwebane, that in fact Parliament may still go ahead with the Section 194 committee?
Good afternoon, Unati, and good afternoon to your listeners, your viewers as well. I think that Bulelani gave a very fair summary of what has transpired in recent weeks. There are really two problems that are raising their heads at this stage. The one is whether the application for rescission of the Constitutional Court's findings in the challenge to the procedure by the Public Protector is an excuse for holding up the process. The Public Protector says it is. The members of Parliament, the Speaker, say it isn't, and they want to get on with the job. Then the other aspect of the matter relates to whether the Public Protector should be suspended while these proceedings are pending against her. And in that regard, she is seeking to have a letter which the Speaker very properly and in the spirit of cooperative governance, which is all there in Section 40 of the Constitution, has written to the President to tell the President that Parliament is getting on with the job because there is, in Parliament's view, no impediment to getting on with the job. So those are the issues that will arise when the matter is heard in court on the 25th of this month, if I understood Bulelani correctly. And it seems to me that what is actually going on a proper analysis of this is that the Public Protector,
President Ramaphosa, in collusion with the Justice Minister Lamola, you don't think perhaps she does have a case?
No, on that aspect, I've already gone public some time ago in the press. The answer to the problem there is that if there is a risk of a conflict of interest, a risk, not an actual conflict, but a risk of a conflict of interest, then the appropriate way forward for the President and what he ought to do is to say to the Deputy President, my hands are tied in this matter. The Public Protector is investigating me on 3 different matters, and she is nervous about a person against whom she is busy mounting investigations, having the power to suspend her while Parliament considers her impeachment. So please, Deputy President, step into my shoes. I am unable to act. You decide whether the discretion which is afforded to the President in Section 194.3 is one which you would exercise in favor of the Public Protector, thereby allowing her to continue without being suspended, or in favor of the National Assembly, thereby exercising the discretion in favor of a suspension while the National Assembly gets on with its work. That's really the high water mark of her case. and she hasn't raised any objections to the deputy president making the decision, and he is in law and in terms of the constitution perfectly entitled to step into the shoes of the president because the president may not be able to act due to the risk of a conflict of interest.
Just recently, in fact, this weekend in Mpumalanga, President Cyril Ramaphosa has been quoted as saying, you know, that the public protector has her job to do and I will do mine. Just with that comment, what are we likely to see in the next coming days and weeks?
Yes, I think when he said, I will do my job, he was basically spurning my advice. He doesn't believe that there is a conflict of interest, and therefore he is entitled to exercise his mind as to whether or not to suspend her. Of course, he hasn't said he is going to suspend her or he isn't going to suspend her. But I think if the matter is properly analyzed, the mere risk of a conflict of interest arising from the fact that there are 3 investigations by the public protector pending against the president ought to persuade him to do his job by saying to the deputy president, will you please make the decision on whether or not to suspend? I think there is a risk of a conflict of interest which precludes me from making the decision. Whether he does that or not, time will tell, but I think that as far as making the allegation which the public protector has made that the speaker is instigating the president to suspend her is really very far-fetched. It is incumbent upon the speaker to advise the president as to what is going on in Parliament in terms of the doctrine of good governance, and the president then has that discretion to suspend her, which he may exercise himself if he feels that the conflict of interest complaint has no legs, or which he may give the job to the deputy president who doesn't have any of those complaints or impediments.
Advocate Hoffman, thank you so much for your analysis. Really do appreciate it.
Thank you.
Advocate Paul Hoffman, Accountability in Now Director.